Welcome to the News Desk, U.S. Law Shield in Houston, Texas. I am Sam Malone. Thank you for joining us today on Facebook Live. We'll obviously cover Second Amendment issues. And while you're watching, you can certainly leave your comments, leave your questions. We have U.S. Law Shield program attorney Matt Kilgo joining us from beautiful Georgia area, Atlanta, Georgia, neck of the woods. How are you, attorney?
Sam, it's good to talk with you. It's good to see you again. We're a little wet here today, but other than that, we're fine.
Outstanding. And look at that $50 tie. Man, you must be a good attorney. Look at the way you're sharp dressed, man. ZZ Top called. They want you in the next video.
I can't grow a beard, so I think I'm out.
I hear you on that one. All right, let's get to the story. And we're going to focus on this one, folks. So once again, you have your questions, you have your comments. Just leave them right there on the Facebook page while we do this on Facebook Live, U.S. Law Shield. Okay, so the Stand Your Ground law out of FLA, not far from y'all, was just ruled unconstitutional. This is amazing. It said a judge ruled that Florida lawmakers overstepped their authority in updating the state's Stand Your Ground ruling. In ruling the law unconstitutional, Miami-Dade Circuit judge said the changes should have been crafted by the Supreme Court in Florida, not those pesky legislators. The Miami Herald reports that the 14-page order is a victory for prosecutors who have firmly opposed the law. Critics have said the law makes it easier for defendants to get away with murder. The controversial law has long been criticized for fostering a shoot-first mentality, which eliminated a citizen's duty to retreat before using deadly force in responding to an apparent threat. I'm lost, Matt. Let me see if first of all, I have to run now. If I'm in Florida, I'm in Texas now, but if I'm in Florida and all those Floridians, now they have to run first. Is this what I'm supposed to understand?
I think what the judge was focusing on is the fact that he felt the law shifted the burden of proving the immunity issue from the defendant to the prosecutor. Now, as you recall, as you well know, as most people know, that there's never a burden on a defendant in a criminal matter unless there's an issue such as this. In Georgia, if we want to use the defense of justification, we have a pretrial hearing. And during that pretrial hearing, the burden is on the defendant to provide some evidence and then to prove that the defendant is qualified for that use of the defense of justification. Thank goodness for the rest of Florida that no other judge in Florida has to rely on this decision, and it certainly doesn't apply to anybody else. I think this judge probably just needs a refresher on what we call separation of powers, a little thing that happened in 1787 when the Constitution was promulgated and signed. Sort of a big deal. We've got that legislative, executive, and judicial. I don't know. I'll send him a tweet.
Yeah. Send him a tweet. Because, as you had mentioned, now the new law requires prosecutors to shoulder the burden of disproving the self-defense claim. So now the prosecutors have to go out of their way to say, no, Matt, you said self-defense, but it wasn't. How would a prosecutor get into your mind? How would they know what was happening in the heat of the moment you were sound asleep and someone breaks into your home and you cap them?
That's a good question. This is the issue that defendants and defense attorneys face, because when we are trying cases like this, we have to get into the minds of 12 jurors and the mind of the judge and, to a great extent, the mind of the prosecutor in order to counter what it is that they're going to present. A lot of really good prosecutors out there, and I think a lot of them think the way that I think and that you think. If we're justified in the use of deadly force, then they have to do justice. They have to do the right thing, which means assisting us in clarifying our rights. And I think this judge just doesn't quite agree with that. See, the rules are a little bit different in Georgia. If we want to use the defense of justification, and we do have a stand your ground law in Georgia, just as Florida does, and it says that, if you're justified in the use of deadly force, you do not need to seek retreat. You can stand your ground and use deadly force to protect yourself, protect any other person, protect your habitation, which is your home, your car, your place of business. If we file a motion, let's say I've used a firearm to defend my family and someone's died, and I've been charged with murder, If my lawyer files, and I would have a lawyer, I wouldn't represent myself. You know the old saying there.
That's right.
Right. If my lawyer files an immunity motion, then we have to have that hearing pre-trial to determine if I'm immune. And that makes a lot of sense. If I'm immune, there's no sense to go forward to trial. So the law in Georgia says you file that motion, got to have that pre-trial hearing. At that hearing, it's my burden, my lawyer's burden, to prove by what we call a preponderance of evidence. That's a lower level of proof than beyond reasonable doubt. I have to prove that I am immune. So I have to present what the law says is some evidence. Well, the law doesn't really say what some evidence is, but you can imagine what that might be. The testimony of me, which we don't like to do, but sometimes we have to do that. The testimony of a witness, anybody who may have seen it, that's always preferable, because even in a situation where you're going to allege or assert your immunity, you don't want to have to testify if you absolutely don't have to. So let's say the judge says, well, no, you're not immune. We go forward to trial. The jury can still hear that this is our defense. And if we provide evidence of this defense, in Georgia at least, it then falls to the prosecutor to prove beyond a reasonable doubt that we weren't justified. So we kind of have – it's two sides of the coin here in Georgia. We have a little bit of what Florida has. We have, I think, a little bit better than what Florida has. But we don't have it as good as some other states, like the state that you live in, Texas. I believe Texas has it creates an inference that you acted reasonably if you're justified.
I think they just – if you show them your CHL, you're done. No, it's here's – let me just – go back a second. And people are piling up with comments. Hello to C. Thanks for watching. Sharon, thanks for watching. And others, as we're on Facebook Live with Matt Kilgo, as an independent program attorney, U.S. Law Shield. Here's what's crazy, and this is why you need U.S. Law Shield. With the laws changing, what if someone's out of town on vacation this week in Florida, right? And they're a responsible gun owner, Matt. They're a proud Second Amendment person that love their country, follow the rules, follow the regs. They went out and got, if it was a CHL or, your license to carry, they gave fingerprints, palm prints, FBI, Social Security, background, $50 and everything. They come back and the law's changed. They may be operating under the assumption of a month ago. Now and this is what I'm saying, this is how tough it is to embrace the Second Amendment. There's now more of a burden on the shoulders of that homeowner in the middle of the night who's like, hey, wait a minute, did I hear Matt Kilgo saying the rules changed because of some court?
Well, and Sam, that's funny. Georgia is a little quirky in how our legislation goes into effect. Our General Assembly meets, I think it's 40 days, so it's sort of biblical, 40 days and 40 nights, beginning in January. When the governor signs new legislation into law, some of it goes into effect immediately. If it doesn't go into effect immediately, guess when it goes into effect? July the 1st. So July is a very tough month, especially for criminal defense attorneys, because most of these changes occur in criminal law. And these are the places where the rubber meets the road. If you're going to have a problem in Georgia and it's a criminal problem, come July 1st, some of those problems can change. So the next month or so, it's going to be a lot of people going, wait, what?
Exactly.
We had a lot of changes in DUI law just in the past 5 days. And so my firm's received a ton of calls about that. There are a lot of changes that have gone into effect about reciprocity in Georgia, about the extension of certain types of privileges with weapons carry licenses. Now, and you'll love this being a proud Texan, before July 1st, you could only carry a knife with a blade up to 5 inches without a weapons carry license. As of July 1st, it can now be 12 inches. So everybody wants a Bowie knife now. So I guess we have to go to San Antonio to get those.
Whoop! Good thing. There are people in America go, that's Bowie, right? David Bowie's knife? No, negative on that one.
No, it's Bowie.
Never. That's right, brother. Remember the Alamo. But, Matt, the bad guys really don't play by the rules. So the bad guys really don't have a calendar. Bad guys really don't care. Wait. Did a new law come in? Did a new law not come in? It goes back to the poor homeowner minding his own beeswax, paying his bills, paying his taxes, being a good husband, wife, mother, father, sister, brother. Here's the noise, and they may second guess, and that second guess may cost them their lives.
From your lips to God's ears. That's why I have an attorney. That's why my 11-year-old, my 7-year-old sons both have an attorney. They know his name. It's Uncle Frank, and they know to call him if they have trouble because I am not going to bail them out. I hope my wife isn't watching.
That was Uncle Frank. But, how is Uncle Frank? He never calls. I constantly call.
He never calls. Well, but no, you're exactly right. Is the people who worry most about the laws are usually the ones who aren't breaking them. And sometimes they're the ones who need the most help because the bad guy doesn't care. Bad guy's going to do what bad guy's going to do, and it's left for the good guy to respond and protect his family, or the good girl, the good woman, to respond and protect her family as best she can.
It's amazing. And then how does it help in the defense? Can you always claim I didn't know the law changed, or I was out surfing that week when the –
Actually, there is a statute in Georgia that says ignorance of the law is no excuse. That's one of the very first statutes that we cover in the book that we wrote. It's Georgia Gun Laws Armed and Educated. And that's on, I think, page 2 or 3 is ignorance is no excuse. And we got to get that out and got to get right up front with it, folks. It doesn't matter if you don't know the law. A very interesting story. The laws have changed about how you can carry in certain government buildings. And we had a fellow contact us who felt he was absolutely in the right. And I looked in the law, and yeah, he was in the right. The sheriff's department was not in the right. Did that mean that they couldn't arrest him? Absolutely not. Even if you're in the right, you can still be arrested. So you still need to be ready to protect yourself.
And going back, in all seriousness, with Matt Kilgo, independent program attorney, U.S. Law Shield, ignorance, and we laugh, ignorance of the law is no excuse. It just makes it tougher. And it's why it's even more essential to have U.S. Law Shield on your side, because things are changing. Laws are changing. And you may, like I said, you may be at Disney that week. Who knows where you were, putting on the mouse ears and eating and taking rides and everything like that. And you weren't up to date, and you come back and you go, I swore the law. No, things have changed. It just isn't easy. It just isn't easy, to follow the rules and regs. I appreciate you taking time out of your schedule there in Georgia.
Absolutely.
Matt Kilgo, who's an independent program attorney, U.S. Law Shield, joining us. It's a great subject. If you just joined in halfway, go, whoa, don't worry. It'll replay. It'll stay on Facebook throughout there, and you can get up to date. And as always, whenever you have questions, if you're a proud Second Amendment person like we are, go to their website, uslawshield.com, uslawshield.com. At the news desk in Houston, Texas, I'm Sam Malone.